rise. Court of Appeals Division 1 is now in session.
Good morning, please be seated. Good morning. This is the time set for oral argument in our case number CR230356, State of Arizona versus Gary Austin Worrell. Each side is allocated 20 minutes for oral argument, although you are not required to use all of your time. If appellant wishes to reserve a portion of that time for rebuttal, you are free to do so, but you need to keep track of your own time at the podium. The clock on the podium reflects your total remaining minutes. Out of respect for counsel and to avoid any embarrassment, for anyone in attendance in the courtroom, please make sure your cell phone is on silent. We have read the briefs, studied the record, and discussed the case in conference, so please keep that in mind as you present your case. As you may know, these proceedings are being recorded and are live streaming. The video will be posted on YouTube following today's proceedings, so I ask that when you present your case, you please state your name and the name of your client when you begin. You may proceed.
Good morning, Your Honors. May it please the Court, Randy McDonald on behalf of the petitioner Gary Worrell. I'd like to reserve some time for rebuttal, and I'll watch my clock. The petition raises 4 claims, of which the trial court dealt with 2, the ineffective assistance of counsel claim and the newly discovered evidence claim. And so I will focus on those claims. If the court has questions about the other 2, the Brady claim or the actual innocence claim, I will be happy to answer.
Counsel, the overall question I have about this is if you resolve the 2 issues that you're going to talk about, right, that necessarily resolves the other 2, it seems to me.
I agree in a sense that the issues are all interrelated. I would disagree that I think that one of the components, one of the reasons that the court rejected the 32.1E claim was that it felt that the defendant was not diligent in uncovering this evidence, and that is not a requirement of the H claim. And so I think this court can still consider that evidence in the H claim, even if it determines that it is not newly discovered in the sense of the 32.1E claim. I agree that the Brady claim is somewhat tied in with the ineffective assistance of counsel claim and the newly discovered evidence claim. This is a case in which all of the claims really stem from the same operative facts.
And on the newly discovered evidence claim, the issue of OI and some bone disorder was a big issue at trial. I understand that your client has an argument here, I have new evidence, but it was really debated at trial. So how is this newly discovered when the argument could have been discovered before trial?
So I think Your Honor's question goes to the question of diligence as to whether the defendant was diligent in uncovering this evidence. And it is true that this issue was a hot issue at trial. And in fact, anticipating that, the defendant, in conjunction with his attorney, went out and found an expert. The expert wrote a very long report that was disclosed. And in part because of the disclosure of that expert and that report, the state went out and got its own expert to refute that evidence. But this case is unique in that none of that expert testimony that was prepared for and disclosed by the defense was actually presented at trial, not because the trial court found that it was precluded, but because the expert simply stopped responding to the defendant's calls, stopped answering the attorney, and instead of attempting to find a new expert or attempting to find a new way to present that scientific evidence, the attorney made the decision not to call any expert, not to ask for a continuance to find any way to present that evidence at trial.
Well, given that the state came up with its own expert who said, who opined whatever he opined, couldn't a reasonable attorney say, I did have this report, the state has responded to that. When I compare the report I have with the state's report, I don't think I want to do that anymore. I think I'm going to do what he ultimately did to contest the confession. Well, you may disagree, I may disagree, but it seems a reasonable decision to make.
So I think what I would say in response to that is that it doesn't seem that from this record that is the decision that was made. In fact, it seems that the decision was to go ahead with the expert, to call the expert at trial, to rely on the expert's testimony, and that because the expert stopped responding to attorneys' phone calls, the attorney simply did not find another expert. In other words, it was not a strategic decision not to rely on that particular type of testimony, but it was simply a failure of the attorney to find an alternative expert or to find another way to introduce that evidence.
Counsel, what is the evidence in the record that demonstrates that proposition? I'm struggling with the speculative nature of crawling inside someone's head to gainsay tactical decisions, particularly given Ms. Jenny's report and the report of the PCH nurse practitioner, all of which counsel had, and I'm looking at trial transcripts that say, hey, look, we screened for bone density issues, we did all these bone labs, run all these extra tests, and all of it's coming up nothing. And then to say, oh, but trial counsel should have doubled down on this and said, oh, hey, let's do this other stuff, let's run these other tests, when there was a legitimate prospect that could have gone very poorly for your client.
Well, I guess I think I would say, in response to that, the underlying, I think, issue with this case is that is the question as to what is a colorable claim and in what instance the court should have held an evidentiary hearing. And I agree that we have not presented definitive evidence that demonstrates what counsel's decision-making process was. But I would say that is the purpose of an evidentiary hearing, that what we have done is we have presented claims, and our claim is that the attorney did not make this as a strategic choice, but instead made it because the expert stopped responding. And I think there are inferences that can be drawn from the record that we have, but I think what we need is for the attorney to get up on the stand and to testify and to talk about his processes.
So what is the standard that the trial court has? Two related questions. What's the standard that the trial court has to apply in determining whether your client is entitled to evidentiary hearing, and then beyond that, once that decision is made one way or the other, what is our standard of reviewing that decision?
Okay, I'll try to remember both of those questions, but if I forget the second one, I hope you'll prompt me. The standard for a colorable claim, I cited it in the petition for post-conviction relief from State versus Bennett, which is a 2006 Arizona Supreme Court case. A colorable claim is one that, if the allegations are true, might have changed the outcome. And I cited it in the petition to this court as State v. Watton. A defendant is entitled to an evidentiary hearing when he presents a colorable claim. That is a claim which, if defendant's allegations are true, might have changed the outcome. So I think our allegations here are that this was not a strategic choice, and that as a result of the somewhat unique circumstances of what happened here, that defense counsel believed that an expert was required, prepared to call that expert, and then that expert disappeared, and defense counsel did nothing. So our allegation is that that was not a strategic decision, but was rather a failure of the defense counsel to do something which he was required to do, that is, present evidence contrary to the state's contention that this medical evidence pointed to child abuse. So that's...
It's not entirely accurate to say that counsel did nothing. Counsel changed course.
I don't think it's accurate to say that he changed course. I believe that counsel at the time was intending to call Dr. Leo regardless of the availability of the other expert. So I don't believe that, other than the fact that...
Counsel, that doesn't seem to jive with the record. I mean, there were pretrial conferences, and just before trial, I think it was very clear what trial counsel's strategy and witness were, and it did not include medical experts.
So the pretrial conference, there is a record of a pretrial conference at which the topic of the expert was discussed, and the attorney mentioned that he did not have an expert and that he would not be seeking an extension of time. But I don't think that from that we can infer that, but for the disappearance of the expert, he would have gone forward without the expert. I think what we can infer from that is exactly what we are alleging, which is that this unexpected contingency happened in which the expert failed to respond to the attorney, that he anticipated calling this witness, that he believed this witness was necessary, and then instead of finding a substitute for this witness, another expert or some other way to introduce medical testimony, he did not do that. And you're right, he called other witnesses. He called Professor Leo as an expert witness and some family members, but he did not fill that void.
I know that he didn't do that, but he had a conversation with his client about it. Am I remembering that right? He discussed this with his client.
There is evidence of a discussion with the client in which he says, we should not ask for an extension, we should go forward without this expert.
Okay, so you have evidence of trial counsel taking a position about how to win this case. How is that not a tactical decision?
I think the answer is that it was not...
Obviously, it didn't pan out, right? I think everybody agrees with that, but how is that not a tactical decision?
Of course, we wouldn't be here if it had panned out. I agree with that. But it was not a tactical decision that was made based on his evaluation of the strengths and weaknesses of the case. It seems to me that...
I disagree. I think that the record shows that they discussed that there was a co-counsel that had experience with prosecution of child abuse, was familiar with presentation of medical evidence of this nature, and made an evaluation about its efficacy, and then made a recommendation based on that. Am I misrecalling that?
No, you're right that there was a conversation about this. And I think our contention would simply be that simply because the counsel made a decision about how to respond to this unique circumstance, that we should not attribute to that some kind of strategic decision.
What's the presumption? What's the standard?
I'm sorry, the standard for...
Ineffective assistance of counsel.
Well, there is a deficiency prong. That is that the counsel fell below an objective standard of reasonableness, and there's a prejudice prong. And I believe that the prejudice prong here is fairly self-explanatory. This evidence was not presented. For the deficiency prong, again, I think I would just emphasize the unique nature of this particular case, where counsel had made an early decision to go forward with this evidence and then decided not to, not because of, and I think you're right, Your Honor, that it is possible to construe this record as what you are saying is that he decided that this was not the most efficacious way to pursue this case, and so did not call the expert. But I think that there is also a way to interpret it, which is he thought that this was what he should do, but just didn't want to find another expert or find some other way to introduce that evidence. And I think that is perhaps why we need an evidentiary hearing.
Let me ask this question, because you talk about the first prong, the deficiency prong.
Yes.
It's a reasonableness standard.
Yes.
Objectively reasonable. So are you saying that this counsel was unreasonable in pursuing the strategy that they pursued?
I don't think that he was unreasonable in pursuing the particular strategy of attacking the confession.
Then how do you win your claim?
Because I think what happened here is that he determined that what needed to be presented was this expert testimony, that he got an expert, he prepared the expert, he disclosed a report.
But this is something that happens all the time. I mean, you're thrown a curveball in the middle of preparing for your case, going to trial, a curveball happens, and you've got to, reevaluate how we're going to go forward now based on this curveball. That's what I see it as. So he made a decision going forward, talked to his client about it, and here you just said it wasn't unreasonable. So again, I'm questioning how do we get here if it's not unreasonable, because we can't fulfill that first prong.
So I guess my response would be that his initial trial strategy, which was expert medical testimony, expert on confessions, that was not unreasonable, and that it was not unreasonable to pursue specifically the challenge to the confession. But what I think was unreasonable was to prepare the expert witness, to prepare a trial that depended on that expert witness, and when that expert witness all of a sudden became unavailable, to simply fill that void. And I don't disagree that some evidence was presented, that he cross-examined some of the witnesses, but he did not do it with the assistance of the expert, and he did not present any of his own medical testimony. And there is a case that I cite, I think it's the Conlin case, that suggests in just such a situation in which the only expert or scientific evidence that is presented is in cross-examination, but that no expert was called to refute the state's expert, that can rise to the level of ineffective assistance.
Counsel, if the attorney has a conversation with the client and says, either postpone the trial and wait to figure to get an expert, or we can go with this other strategy now, given what we have. How is that not a reasonable choice? It may be one that you disagree with, or that we might disagree with, but hindsight is a lot better than foresight.
And I think what the record demonstrates is that it was not a conversation. It was, this is the way that I think that we should do this, and that the other attorney was called in as a means to compel the client to make the decision that the attorney wanted to
Your
make.
client could have said, I really believe that the child has this condition. That's the truth of the matter, and I want that truth vindicated. He could have said that. I mean, there wasn't a gun to his head. There wasn't evidence of his will being overborne.
I think I agree that there was no gun to his head, but I think that the evidence does suggest, or what we have presented suggests, that the attorneys applied a great deal of pressure to convince him to make this decision.
All I'm doing is giving him the best legal advice, which is what their job.
I agree that is an inference that could be drawn from the record here. And I know that my time is short. I do want to discuss the newly discovered evidence question. And I think the main point that I want to make here is that I believe that the trial court applied an incorrect standard in determining whether it should grant a evidentiary hearing. It wrote that, that the evidence of OI or Ehlers-Danlos syndrome was not definitive. And on the second page of the decision, they wrote, the defendant bears the burden to prove allegations by a preponderance of the evidence. So I think it appears from the record that the court applied the incorrect standard in determining whether to grant an evidentiary hearing, which is if the allegations taken as true would grant the defendant, would lead to the defendant's claim being granted. It seems that the court applied a more stringent standard and said because you did not prove the 32.1E claim in the papers, that we are not granting an evidentiary hearing, and I think that's the incorrect standard, and I think this court should reverse as an abuse of discretion for applying the incorrect standard. I do want to reserve some time if there are no more questions.
We'll have questions, but you can reserve your time.
Thank you.
So I am going to hype up the argument, but can you answer the last point that you covered?
Sure. Let me go ahead and start off. Good morning, my name is Scott Blake. May I please the court, I represent the state of Arizona as a deputy county attorney with the Yavapai County Attorney's Office. Going to that last point, in the state's response to the defendant's petition for post-conviction relief, the state cites a case, State versus Herrera, in which in order to successfully prevail on a post-conviction relief proceeding, the burden, there must be a showing of provable reality, not mere speculation. Here, what the petitioner is relying upon is mere speculation. There's an indication this is newly discovered evidence. However, in the petition itself, it indicates there's a diagnosis of the osteoporosis or the Ehlers-Danlos.
You mean osteogenesis imperfecta?
Yes, osteogenesis imperfecta. There seems to be an indication that there was a diagnosis. However, that's not the case. This is just mere speculation. Looking at Exhibit 27.
Counsel, isn't that a subject for a evidentiary hearing? I mean, you make an allegation that's based off of something that's not entirely speculative. There was a genetic test. There was a result that says there is this gene abnormality and that it can dispose, and I agree with you, can dispose someone to those maladies is not proof that there are those maladies, but is that not the subject of an evidentiary hearing?
I think that's, if there would have been a diagnosis, then that should be a subject of an evidentiary hearing where the state could call an expert and the petitioner could call an expert and they could discuss if this diagnosis would have contributed to this. And if there is this diagnosis and what is the degree of this diagnosis. But here we have a situation where it just can. It's essentially saying high blood pressure can cause strokes, can cause heart disease, can cause heart attacks, but high blood pressure in itself isn't determinative of these other elements. So
that just reinforces that there's a factual question outstanding. You have an indicator, you don't have proof. How do you determine proof? You hold an evidentiary hearing. So why doesn't he get an evidentiary hearing? That's the question.
Because at this point, it's just mere speculation. There wasn't any supplement of the record. There wasn't anything this test was done, the evaluation was done back on basically a year from today, January 25th of 2023. There was no further testing. Anyone can make allegations after the fact and say this is newly discovered, this is an allegation of...
Okay, step back. Did the genetic testing exist at the time of trial?
It did not.
Okay, so after trial, there is a genetic test, and that genetic test comes back and it indicates a problem with a gene. And the problem, a mutated gene, okay? So that doesn't strike me as like out of thin air. It's something, I totally agree that, you can take all kinds of shots at this. You could say, well, it's a take-home test. There are no laboratory parameters in collection. There's, there are problems in chain of custody and all that sort of stuff. I get all of that, but all of that goes to weight. So why don't you get a hearing?
I think it's opening the door in situations, and in every post-conviction relief proceeding, someone can make a mere allegation of there's this potential new evidence that hasn't been substantiated. If there was some substantiation to it and not mere speculation, then yes, the state would believe that there should be.
So what do you believe would be substantiation?
An actual diagnosis, actually something showing that this was in fact, this victim did have this diagnosis, not can be diagnosed or this can result in a potential diagnosis. That's going
Isn't a fact that says that, because the general understanding is that where there's smoke, there's fire. So if someone says, hey, there's smoke, let's investigate whether there's fire, and what you're saying to me, if I understand it correctly, is, no, you got to know there's fire before we investigate whether there's fire.
I think it's on the petitioner to provide that to the court. I mean, he hadn't since...
Is that the standard? You must know there's fire before you can investigate whether the smoke means fire?
According to State versus Worrell, there has to be, it's not just mere speculation. There has to be something more than mere speculation. Here, this is still mere speculation. The petitioner had time until the court ruled on this to get a diagnosis. This took place on January 25th of 2023, this evaluation. The ruling didn't come out from the court until...
I don't know that I agree with that, but let's move past it. So we get to the second question, which is, so what?
And that's the state's other point is, even if there was a diagnosis, the trial court still got it right in the sense that it still wouldn't have affected the outcome of the trial. Here, the linchpin of the state's case was the admissions or confessions of the petitioner. Essentially, reading from the facts from the Court of Appeals, this court previously, there was a finding that there was a popping, that he pushed the arm to the point that it popped. So regardless, there's still, even if there was a medical deficiency, even if there was this diagnosis, the fact that he admitted to essentially committing the child abuse in the sense that he pushed the arm so hard that it caused a popping.
I'm sorry.
So the crime would have occurred. The crime would have occurred whether the child had a bone abnormality or not.
Correct. There was still a lot of times in these situations. If we were dealing with a situation where there's no confession, no admission, we just have individuals that were in the household. We have medical records that show fractures, that show these situations occurring. then, and especially when there's testimony that was provided by the state that these appear to be consistent with child abuse, then you look to see, okay, who committed this child abuse? Here, the situation is you have an individual that admitted to performing this. At some point, you take your victim as they are.
Did he concede at trial, or did he say that with his position at trial that he didn't admit it, or that's not what I meant when I said those words?
And that goes back to the original point, why it was a strategic decision from his trial counsel to attack his admissions or his confessions.
Well, assuming that the evidence would show that the child had a gene that would create the possibility that he had a bone abnormality, wouldn't that feed into the question of whether the defendant is credible or not? If he's saying, I was forced into the statements that I made, look, my child has this abnormality, that affects the jury's evaluation of the credibility, correct?
But the situation here is he admitted that he pushed forcefully on this arm to the point that it popped.
Did he concede that at trial?
Correct. Well, he didn't concede that. He challenged that at trial, but that was an admission that he made to law enforcement, and that's why it was a strategic decision.
But my point is that if the child was disposed toward an abnormality, if he had the evidence submitted to the jury, that would support his claim that his confession was false.
No, not necessarily, in the sense that we see that there was they challenged that, and the jury still found that. So I think that is different than saying they challenged the admissions. They challenged gravely the admissions. The state doesn't believe that would affect the jury's outcome by.
And let's take a hypothetical that the child did indeed have OI, but he still confessed to the police of injuring the child. If he comes to trial and says they improperly coerced the confession out of me, those are false admissions, wouldn't the existence of the OI indicate that yes, that the confession was false?
The state doesn't believe so. The state believes that, obviously the state believes that his admissions were not coerced or forced, and that he admitted this because this is what he did.
But the jury it's not up to the state or the court, it's for the jury to make that determination. And if the child did have OI, that would affect their evaluation of the credibility of his argument. I would hope you would agree with that.
I think it might be something that would contribute, but I don't think it would ultimately make a determination on the jury's outcome, especially when you had this confession, what he did.
If I could go back to the newly discovered evidence, the test was new in the sense that it occurred after trial, but did they have the ability to do the test before trial and did not do it?
Of course, they had the ability to do the test before trial.
So doesn't that affect the newly discovered evidence claim? Because They could have discovered that before trial.
That would be the state's the state's argument, is that they had the ability, they had actually hired an expert, they had, there was some discussion on this. There was disclosure of the state's expert. They had that ability. The child was in protective, was with DCS at the time. However, there could have been a motion that was filed with the court. However, they made a strategic decision not to go that route, but to go after the confessions, because the confession was the linchpin of the state's case in this instance. You have a situation where we're not just looking at the causation, how were these caused? We had an admission, there was an admission to the causation of how this was caused. There was admissions by the petitioner that he forcefully pushed this arm to the point that it popped. And so that was a strategic decision by trial counsel, after consulting with another attorney in his office who was a former prosecutor that had done child abuse cases, and the decision was they needed to attack or to try to mitigate the admissions that were made, and that was an appropriate strategic decision that they made in that situation. And so ultimately, the diagnosis would become irrelevant. It was not essentially new evidence, because there would have been this ability to do this testing and to go down this route, but there was a decision not to go that route because the admissions were so detrimental to the case. That's what the focus became. And so the state believes that the trial court did act appropriately and did find that the dismissal, that there wasn't a colorable claim of ineffective assistance of counsel, that the new evidence wasn't essentially new evidence. It wasn't definitive evidence, as indicated by the court. And the court ultimately held that it was the admission, even if the evidence came in, the admissions would not affect the outcome, or because of the admissions, there wouldn't be a change in ultimately what the jury found in this case.
So counsel, if the new evidence was that the child was actually diagnosed with this disorder, would that be a change in circumstance?
The state does not believe that. The state believes that given the admissions and confessions of the petitioner, that the jury would have still came to the same conclusion. Yes, there would have been some mitigating factors in the sense that this child had a condition. However, even looking at the record between the two counts, the petitioner, there were some admissions that the petitioner knew that the child had some bruised ribs from this prior conduct with the changing table. But even though there was these bruised ribs, he knew that there was some injury to this child. There was a second conduct in which there was this forcefully pushing of the arm to the point that it popped. That by itself, regardless of what the diagnosis is, would show that this individual engaged in this conduct, and the jury would have still found, regardless of if the child was diagnosed with this condition or not.
Thank you.
Any other questions for me at this time? The state does believe that the trial court did correctly rule in this case, that the dismissal was appropriate, that it followed the law, it applied the appropriate standards, and the state would ask that the court affirm the trial court's decision to dismiss the petitioner's post-conviction relief petition. Thank you.
Thank you, counsel. Mr. McDonald?
So I want to talk about the newly discovered evidence claim. The questions previously revolved around sort of three prongs, whether the evidence exists. That was the sort of smoke and fire analogy that I think you were making, Judge Faruya, whether the defendant had diligently pursued it, and whether the evidence would be material. There were some questions about the diligence prong, and while it is true that the possibility of getting this evidence existed before, effectively what the defendant had done is he hired an expert and said, this is a thing that I want to investigate. You are an expert in this. We trust you. And then they were abandoned by that expert. The expert disappeared from the face of the earth, stopped responding to calls. And so I think to impute the failure to get the testing to the defendant in that situation, I think is inappropriate.
Counsel, I keep coming back to this, and our Supreme Court recently decided a case on these on these issues. It's State v. Bigger, and I'm going to read you from paragraph 10, and it says, "We presume counsel acted properly unless a defendant can show that counsel's decision was not a tactical one, but rather revealed ineptitude, inexperience, or lack of preparation." So the important part in here, because I understand you're saying, oh yeah, inexperience, ineptitude, or not inexperience, but ineptitude and lack of preparation. But the presumption part is what gives me pause there. Our presumption, do we not have to start with the presumption that trial counsel did this as a tactical decision?
And, Your Honor, I'll concede that that's what Bigger says, and I agree that the IAC claim is the diligence, not the diligence, the first prong of the Strickland standard is a high one, and I agree with that, and we've had some discussion about that, and I agree that there are some issues with that. I guess I want to focus on the newly discovered evidence claim, which is different, and the diligence prong of the newly discovered evidence claim is different than the Strickland claim. And I think in that claim, in the newly discovered evidence claim, to impute the expert and the attorney's failure to get this test when the expert had effectively abandoned the defendant, I think that is difficult for me to swallow, that because the defendant hired an expert and that expert abandoned the defendant, that the lack of the expert's diligence should be imputed to the defendant.
Counsel, I'm sorry, but you're out of time. We can add some more time if you...
Yeah,
Okay.
that's okay.
All right, we appreciate your presentation today. We appreciate your briefing. We will take this matter under advisement and issue a written decision in due course. Court is adjourned.